Hi, everyone. My name is Andrew Dennis. I'm the founder and owner of Ibis Prep, where we have an instructor for every subject under the sun. And I'm here today to teach you all about real property for the MBE. And you can see I'm reporting live from the Grand Canyon, where in 2018, I rafted with my older brothers and their friends for 3 weeks with no computer, no phone, just our supplies on the raft. It was a really, really amazing experience, and I have some amazing pictures from that trip. I always like to start off with just a little bit of information about my company so you know who we are and what we do. You see, we have an amazing team. Alexis Simran and I are in the administrative team. And then Jason Billups does our securities department, Series 7, 66, SIE, the exams to become a stockbroker, financial planner. And then these are 4 of the members on the bar prep staff. We do the MBE, we do the Florida bar, Louisiana bar, California bar. We're expanding into other states, and we can help you with every single element on the bar exam. If you feel uneasy, a one-on-one tutor really is the best way to reinforce your knowledge base. Then we tutor for the NCLEX for nurses, LSAT, K through 12 subjects, Spanish. We do computer coding, all sorts of fun activities. Really, really great staff. I'm really proud of the team that I have, and we're always building. You can see 5-star reviews on Google. Take a lot of pride in the work that we do and providing top quality service. And then as far as the bar and the bar prep, what you can do is go on our website and see different packages, different hourly packages, 5, 10, 20, 40-hour packages, buy pre-recorded materials, and just get to know our team a little bit more. So that's that, ibisprep.com. You can find us. We're on Instagram, Facebook, all those things. So let's start with the motivational quote. If you can't explain it simply, you don't understand it well enough, by Albert Einstein. That's a truly remarkable quote for what we are trying to accomplish with the bar exam. We need to understand these things well enough that we can explain it simply. Explain it to your dog, to your cat, to your sister, to your brother, to your mother, to your father, to your husband, to your mirror. Explain to someone simply these questions. Ideally, not your mirror. If you can find a real person, even if they're an 8-year-old kid, even if they're a baby, but there's speaking to a baby or the mirror helps. And not saying that a baby is not highly intelligent, but they can't really respond as well, is helpful, because just saying it aloud makes you reinforce your understanding of it. That's part one. But saying it to someone who's, interested and can ask questions and can challenge you, that really is a good way of proving to yourself that you really know it well enough and you understand it well enough. So Albert Einstein, I'm a huge fan of Albert Einstein. I remember he got a D in one of his subjects in high school, and then he ended up being recognized for his brilliance. So don't let other people, their perceptions or judgments impact your perception of yourself. You can still achieve great things no matter where you are. And if you're studying for the bar exam, that's a really great sign. You're in a small percentage of the world who's put themselves in position to practice law. So let's begin with real property and our PowerPoint. I'll start with ownership interest. Property law wants the owner to always belong to someone. So we always want someone to have the property. That's why we're going to have things like the rule against perpetuities and things of that matter. No lapses in ownership is allowed. So even if the property is currently with someone, for instance, a life estate, we're worried about what happens when they die. Courts don't want to decide for people. So the most common type of estate would be a fee simple absolute. This is going to be presumed if there's an ambiguity, that you have the property in fee simple absolute, which means you're entitled to convey the property, to take a mortgage on the property. It's your property, and you're not worried about what's going to happen after it. If you're worried about what's going to happen after it, it's likely the feasible fee. So in property, we assume the person tends to give the most they have. So fee simple is like a tenancy in common. in the sense that when you talk about a tenancy, you're talking about the entire property. When you talk about a conveyance of land, you're talking about the entire property. Typical language, A transfers land to B, or A transfers land to B and his heirs. We do not say all the land, but this is a fee simple because we presume the person is giving the most they had to give. Okay, simple on the first slide. Fee simple, ownership of all the land, and it's pretty unconditional. Whereas the feasible fees, we're going to have three types: fee simple determinable, fee simple subject to conditions subsequent, and fee simple subject to an executory interest. So fee simple determinable is going to be to Andrew so long as it is used for these purposes. To Andrew until for Andrew to use as a garden, as a garden. If I stop using as a garden, it'll automatically revert. So fee simple determinable, we're going to think of those automatic reversions. It automatically reverts to the grantor. Fee simple subject to condition subsequent is going to mean that there will be a condition, but if Andrew uses it for this purpose, then the grantor retains the right. So when you're looking at fee simple subject to condition subsequent, look at right of reentry by the grantor, a right, not an automatic condition, and then look at some happening or event that's going to trigger that right of reentry. So fee simple determinable, automatic reversion and grantor. Fee simple subject to condition subsequent, we're talking about a right of reentry where the grantor could reenter if they so choose upon a conditional subsequent event. Then finally, fee simple subject to executory interest. Here, look for the future interest vesting in a third party. So it's going to A to B for life, and then to C. Well, after the life of B, C will have that remainder. That remainder is known as an executory interest. In fact, that executory interest will be a shifting executory interest that shifts from B to C. If it's to A to B, but if B uses the property for farming, then to C. Well, C has a shifting executory interest. A springing executory interest is if it springs from the grantor to the third party. To B, when B gets married, it'll spring from the grantor to B. To A, so long as it's used for farming, but if it's used for commercial, for a basketball gym, then to C, well, then C will have a shifting. It shifts from a grantee to another third party. It springs from a grantor to a third party. So we'll go over all these things in detail when we go over my outline. I'm going to go over the PowerPoint, the outline, and the cram guide. So don't worry. This is all about repetition, hearing things aloud. Play this in the car or when you're driving or when you're walking, to just hear these things over and over and just nod your head like, I understand, that makes sense. Let's look at some examples. Andrew conveys land to Letty while she continues to use the land as a library. Fee simple determinable because it's durational and it will automatically revert to grantor. Letty conveys land to Andrew during its use as a library. Exact same situation. Fee simple determinable reverts back automatically to Letty once I stop using it as a library. Andy conveys land to Letty, but if the land is not used as a library, Andrew may re-enter and take. Right of re-entry, subject to condition subsequent. Letty conveys land to Andrew on the condition, subject to condition, the land is used as a library. So that's going to imply a right of re-entry, and it's going to be subject to condition subsequent because it says that conditional language. Conditional language, right of re-entry. Durational language is going to be automatic reversion. Letty conveys land to Andrew and his heirs, but if the land is not used as a library, then to Amy. Amy will have a shifting executory interest. Why does this distinction matter? Fee simple determinable, future interest possibility reverter vests automatically. Fee simple subject to condition subsequent, future interest right of reentry does not vest automatically, it has to be claimed. Fee simple subject to executory interest, the future interest executory interest, the key is the land does not go back to the grantor. Perfecto. Okay. Life estate doctrine of waste. Estate measured by life. Termination is the measuring life dies. Accompanying future interest is a reversion if to the grantor or a remainder to a third party. So that third party executory interest after a life estate will be a remainder. Words on the MBE for life. To A for life, and then to B. A has a life estate, B has the remainder. Can the life estate holder devise the property? No, it's not his to give. Can the life estate holder pass the property through intestacy? No, it's not hers to give. Doctrine of waste. Numerous parties have an interest in one party. Courts are worried what happens to the party after the life estate. Courts trying to protect the current and future interests. There's three types of waste: affirmative or actual waste. So that's actual action. You beat up the property. Permissive waste, you let it rot. Lack of action that devalues the property. And ameliorative waste, you do something that actually increases value to the property. You build a rose garden, but it's still going to be considered waste because you weren't had the permission to do that. Other rights I can think of: if you're a life tenant, you have to pay the taxes and the interest on the mortgage. If you're a remainder man, you have to pay the principal of the mortgage. Okay. Concurrent estates, real property owned by two or more people. MBE tested rule: concurrent owners have a right to use and possess the whole, right? So you can't restrict a joint tenant from using the property. If they want to live there, you can't say they can't. Even if you rented out your room, they still have a right to their room, 50% of the property. Well, it depends, 50% or 100% of the property, depending on how the estate is created. So when you're denied your right as a tenant, you have been subject to an ouster, and you can seek relief from that. So the main types of estates: the TIC, Tanzanian Common. This is default, no right of survivorship. If A and B are tenants in common and A dies, A's estate will descend to A's heirs. There's no survivorship between the tenants. Joint tenants with right of survivorship, we have the four unities: time, title, interest, and possession. Well, here we're going to have a right of survivorship, meaning A and B, JTROS, A dies, well, B will take it will survive A, and B will take entirety of the estate. If it's severed, it becomes a tenancy in common. There's some ways that you could sever a JTROC. If you get a mortgage on the property, it depends if it's lien theory or title theory. In a lien theory state, getting a mortgage on the property will not sever the joint tenancy. In a title theory state, it will. Tenancy by the entirety is the same for unities: time, title, interest, and possession, plus marriage. It'll be assumed if we have all those. Okay, so creating a joint tenancy, you must have the four unities: time, title, interest, and possession. Joint tenants receive their interest at the same time. Joint tenants receive their interest in the same instrument. Joint tenants receive the same interest. So if one party gets 1/3 and the other gets 2/3, that's not going to be the same interest. And possession, they have the equal right to possess it as a whole. So to clarify what I said earlier, for tenancy in common or JTROS, you have a right to possess it as a whole. It's only if there's been some sort of what we call it, partition, then you would only get a right to 50%. Before then, you get a right to the entirety of it. Okay. In lien theory state, a mortgage is just a lien and does not destroy joint tenancy. In a title theory state, a mortgage severs title, so the joint tenancy is severed and becomes a tenancy in common. Like I said, if one party gets a mortgage on it and they tell you that's a lien theory state, it's still a joint tenancy with right of survivorship. If one party gets a mortgage on it and it's a title theory state, then the joint tenancy with right of survivorship will become a tenancy in common. Landlord Attendance. A lease is both a contract and a property interest in land. The tenant has a duty to pay rent and avoid waste. The landlord has a duty to maintain the premises, mitigate damages, deliver actual possession, and duty to repair. Whether they have the right to deliver legal possession, like it depends on the state. It has to actually say, like if there's someone else there living there and they've given them all other rights, like they gave them the key and everything, do they have to evict the person? That actually depends on the state law, but they always have to give them right to possess. Okay, 4 types of tenancies. Tenancy for years, that just means for a fixed time period. It's not for multiple years. It could be a fixed time period. It terminates automatically. Periodic tenancy is repetitive and ongoing, month to month, year to year. Must be given proper notice of termination. Tenancy at will, express or implied. It may be terminated by either party at either time. A tenancy at sufferance is like a holdover tenant, someone who stayed there longer. Fancy word for the awkward period of time between landlord evicting a tenant and tenant staying unlawfully. Eventually, the tenant will be evicted, leaves, or enters a new leasing scheme. So, there's different rights depending on the state too for tenancy at sufferance, and we'll go over these in detail. But landlord tenant issues, types of tenancies, lien theory versus title theory, waste doctrines, life estates, fees, defeasible fees. This is all good stuff. And we're going to go over everything and make sure we understand this. Okay. Implied covenants of quiet enjoyment applies in residential and commercial settings. Tenant can choose and not to pay rent when the landlord takes actions that make the premise wholly or substantially unsuitable for intended persons and rise to the level where the tenant has been constructively evicted. So in the landlord tenancy agreement, you also have these implied covenants of quiet enjoyment and habitability. So quiet enjoyment, if it's, you're not able to use the land for its intended purpose. The premise is unsuitable for its intended purpose. You notify the landlord fails to correct the problems, and you vacate the premise, then you could sue for constructive eviction. Remember, for constructive eviction, you have to actually vacate the premises. Whereas habitability is only residential settings, not commercial settings. Quiet enjoyment is both. Cannot be waived. Law wants to protect the tenant. The warranty holds the landlord has a duty to maintain property to ensure it doesn't threaten the life and safety of a tenant. Failure to comply with the housing code is usually a good indicator that the warranty has been breached. Right, there's bugs everywhere. The tenant does not need to vacate the property. So you do need to vacate for quiet enjoyment. You do not need to vacate for habitability. For constructive eviction, you have to actually vacate. Sublease versus an assignment. So key thing here is an assignment is going to be the totality of the lease, where a sublease is just going to be partial, and the assignment of the lease will include privity between the landlord and the new tenant, where a sublease will not. So a landlord leases apartment to A leases apartment to B. Privy of contract versus privy of estate. The landlord needs some privity to collect rent. So the sublease, you give less than what you have. So the landlord has no privity of contract or estate with the sublessor. Assignment, you give everything you have, a complete transfer of tenant's remaining term. The landlord could cover from both, remember, not just the new tenant, but the original too, because you have privy of contract with the original and privy of estate with the new. The landlord can recover from both the original tenant and the person who takes the assignment because there's privy of estate. Andrew rents Letty's apartment for 1 year, 7 months into lease. Letty subleases her apartment for summer term of 3 months. Can Andrew collect from Letty? Andrew collects from Letty, of course. Can Andrew collect from Sam? No, because there's no privy of estate between Andrew and Sam. Can Andrew collect from both? No, because this is a sublease, not an assignment. Okay. A land sale contract. 2 moving parts, the contract and the deed. Always remember the doctrine of merger. So the contract is what the parties sign. The deed is the legal instrument which delivers title. So it must be delivered with present intent to transfer and accepted. Must have words of transfer, including the statute of frauds requirements. So adequately describe the land, the type of deed it is. It depends if it's a general warranty or a specific warranty or special warranty. A deed, and it'll be recorded with the county likely. So the doctrine of merger. Covenants of contract are merged into deeds. So once deed controls, everything must flow from the deed, right? You can't sue on the contract. You have to sue on the deed after the deed has been created. That doctrine of merger, the contract will merge into the deed. Look for that answer for sure. Implied covenant of marketable title. Title is free from risk of unreasonable litigation, right? Even if it's not present litigation, if it's like something that would cause rise to litigation, that's not marketable title. If there's a encumbrance on the property, an easement, that's not marketable title. Risk of loss after contract but before deed, right? So that's going to be equitable conversion, where after you've signed the contract but before the closing, when you're in that period of escrow, the risk of loss is actually going to shift to the buyer. The buyer holds equitable title during this awkward time period and has the risk of like a fire or something. Statute of frauds reprised, so it must be in writing, signed by the person to be charged, essential terms, parties, price, and property. And the exception to statute of frauds will be part performance, possession, payments, or improvement to land. Okay, some last topics, and again, we're going to talk about all these things in detail on my outline. Adverse possession, so ocean, open, continuous, exclusive, adverse, notorious. Easements, implied easements, explicit easements, easement appurtenant, easement in gross, easement by prescription, easement by necessity, lots of easements. Mortgages, mortgage is going to be two different documents. It's going to be the actual mortgage itself, and then it's going to be the security agreement. So it's going to be like a contract that's similar to like a commercial paper instrument almost, because it's an agreement, right? To pay back money. And then it's going to be similar to a security agreement, and where you use the property as collateral. And there's going to be a whole bunch of different rights. And of course, what's going to apply is recording statutes: notice, race, and race notice. Notice, the bona fide purchaser will always prevail. Subsequent bona fide purchaser will always prevail. Race is the first one to record, and race notice is the first subsequent bona fide purchaser to record. Types of deeds: general, special, quitclaim. There's going to be 6 covenants to general warranty deeds. We need to know them all. There's going to be present, and there's going to be future. Let me take a crack at them. Present, and if you're watching, you could like try and get this faster than me. Sizing, right against encumbrances, and right to convey. And then future is going to be general warranty, further assurances, and quiet enjoyment. I could have got them not perfectly right, but I did my best. I'm only human. And then nuisance. We talked about nuisance already in torts, but it applies. And there's some more things that also apply, and we're definitely going to talk about all of them. So, you can follow us on Facebook, LinkedIn, and Instagram. We're out here. Let's go look at the outline and see if we can put some fun things together. All right. So defeasible fees, we already talked about this. An estate with the remainder vested in some person, but that person may lose his interest upon the occurrence of some of it, requires clear words of intent for the remainder to vest. Words like mere desire, hope, or aspiration are insufficient. It is my hope to give this property to Johnny. No, it is I give this property to Johnny. Fee simple determinable, we already said. Automatic, possibility of reverter. From A to B, so long as Blackacre is used to rescue cute puppies. Once B fails to use Blackacre for cute puppies, not sure why someone would, but people are weird. A has a possibility of reverter, right? And it's going to be, A has her, I'm going to even change this to automatic reverter. No, it's still possibility. I'm going to say possibility of automatic reverter to clarify, like just. Okay. Fee simple subject to condition subsequent, we talked about, right? It's right of reentry. And then fee simple subject to executory interest. It's going to be a shifting executory interest. As I said, it's going to shift from the grantee to a new third party. Fee simple determinable, automatic forfeiture, potentially infinite, and it's still transferable. Alienable, divisible, and ascendable, subject to the occurrence of a given event. Creation requires clear orational language. Be on the lookout for phrases such as so long as, while, during, until. A for so long as you practice guitar. If you practice guitar, property automatically reverts back to grantor. Words like desire, hope, or aspiration are insufficient. Accompanying future interest, possibility reverter. Grantor retains possibility reverter. Fee simple subject to condition subsequent. Grantor retains the power to terminate grantee's estate upon the happening of some given event or condition. The characteristics: forfeiture is not automatic. If the event or condition occurs, the grantee still retains title until grantor takes some action to exercise right of reentry. We distinguish the main difference from fee simple determinable. It's potentially infinite, and transferability is alienable, divisible, and ascendable, subject to the occurrence of the given event or condition. Creation. Clear conditional language must carve out a right of reentry for the grantor. To A, but if he wins the lottery, grantor reserves the right to reenter and take. Like always, words of mere desire, hope, or inspiration are sufficient, right? So conditional language and right of reentry. That's what you're looking for in fee simple condition subsequent. Grantor retains right of reentry. Fee simple subject to executory interest. The property automatically transfers to a third party upon the happening of a given event or condition. Automatic forfeiture. Upon the occurrence of the given event or condition, the state automatically transfers to a third person, similar to fee simple determinable, but ownership automatically transfers to a third person, not grantor. Potentially infinite. Duration is potentially infinite so long as the event or condition does not occur. And transferability. Alienable, divisible, and ascendable serves the occurrence of the given event or condition. Clear language of rights vesting in third person is required. To A, but if A ever owns a cat, then to B. Like always, words of mirror, desire, hope, or aspiration are insufficient. So to A, but if A ever owns a cat, then to B, B has that springing executory interest. Future interest. So we're going to dive a little bit deeper into here. Possibility of reverter, right of reentry. We talked about that. Possibility of reverter is fee simple determinable. Right of reentry is fee simple subject to condition subsequent. Reversion, default future interest for grants of an estate smaller than a fee simple, such as a life estate. To A for life, to A for 99 years. Remember, fee simple absolute gives everything you have, the whole pie, but you can carve out a piece back to yourself at the end, then look for reversion. Future interest in grantees or third persons, you have vested remainders, contingent remainders, and executory interest. Vested remainders, indefeasibly vested remainders subject to total divestment, and vested remainders subject to open. Vested remainders subject to open, contingent remainders, executory interest, we'll talk about, are all going to be subject to the rules against perpetuities. We're going to go deeper into these things, don't worry. So a future interest in a third person that arises immediately upon the termination of a preceding estate is called a remainder. The characteristics of a remainder: expressly created in some conveyance in which the preceding estate is created, never follows a fee estate. It cannot follow a fee simple, which is potentially infinite, right? It will never follow a fee simple, it's a remainder. Cannot cut off or divest an interest held by a prior transferee, and alienable, divisible, and descendable, right? So it's not going to cut off or divest it, it's just going to come after it. Now we have vested remainders and contingent remainders. There's three types of vested remainders: indefeasibly vested remainders subject to total divestment or executory limitation, and vested remainders subject to open. We're going to go through all of them, don't worry. And then contingent remainders. So these are not vested. There's a condition precedent to the future interest becoming possessory. The future interest vested in an unascertained taker, or both A and B. Contingent remainders are going to be crucial rule against perpetuity considerations. Okay, let's look about the vested remainder. So we understand 2A for life and then 2B. That's a vested remainder. A remainder that automatically becomes possessory upon the natural expiration of the preceding estate. Limitations: vested remainders cannot be subject to any condition precedent. My dog Rosie is snoring. She's always snoring. I'm sorry. And they cannot vest in an unascertained person. So they're vested, right? They have to be subject to no condition, unconditional, and ascertainable. Three types of vested remainders. Indefeasibly vested, that's the strongest one. To A to B and then to C, it's indefeasibly vested. Becomes possessory upon the immediate termination of the prior state. Vested remainders are subject to total divestment. So total divestment means it could totally be divested or defeased. Subject to condition subsequent such that remainder man can be divested after taking possession. To A for life, remainder to B, but if B weds, then to C. Well, see how it's to A for life, then to B, B remainder man, but subject to total divestment, because if B weds, then to C. So there's actually a fourth party here, or a third party here. Well, fourth party if you include the grantor. Grantor to A, remainder in B, subject to total divestment. It's vested because it's definitely going to follow the estate. That's what makes it vested. What makes it subject to total divestment is that it can totally be taken away. Vested remainder subject to open like a class gift. Remainder vested in a described class of takers, at least one of whom is capable of taking possession by virtue of being alive, not conditioned to any condition precedent. So vested remainder subject to open is a vested remainder to A to B, then to A's children. Well, A could have more children. That's what keeps it open. Class remains open to allow for future class members. Anyone who satisfies the description, children of A, and closes when additional class members are impossible. Right? Well, it would close when the parents have passed. Now, we do have a rule of convenience. They might have to mention that's being used under the rule of convenience. A class will close whenever any class member can call for distribution of a share. It does not apply if it conflicts with the grantor's express intent. So the grantor's express intent will always prevail. But basically, if it said, to Andrew's children who reach the age of 21, well, once the first kid reaches 21, because we want to start giving that kid his shares, we'll close the class. So any kid who's born will take. Kids who are born after won't actually take from that under the rule of convenience. Okay, contingent remainders. These are also going to be subject to rule against perpetuities, which we'll talk about. A remainder subject to a condition precedent, which must be satisfied before the interest becomes possessory, includes remainders in unborn or unascertained takers. The remainder is contingent on the grantee being born or ascertained. Once the grantee satisfies the contingency, the interest automatically becomes an indefeasibly vested remainder. To A for life, then to B and his heirs when B gets married. If B is unmarried at the time of the conveyance, A has a life estate to A for life, life estate in A. Then to B, B has a contingent remainder because it's when B gets married. When B gets married, because it's precedent, and the grantor has a reversion in case B is not A when 21 is in case B is not 21 when A dies. See rule against perpetuities, right? So to A for life, and then they're saying in case B is not 21 when A dies. So if A dies and B is not 21, we'll look at how that could affect the rule against perpetuities. I don't want to confuse anyone right here. Just know that a contingent remainder is after a life estate, but subject to a condition if B gets married. Okay, we can talk about the rules of destructibility, merger rule, Shelley's rule, and the doctrine of worthier title. Again, they're going to say these have mostly been destroyed. These are common law. So these are common law rules. If they say they've adopted the modern view, you should know about these. I'll just go through them briefly. They're not tested much, maybe once per test. Rule of destructibility. At common law, a contingent remainder is destroyed if it remains contingent. The condition is not satisfied when the preceding state ends. O grants for A to life, then to B once he goes to law school. A dies and B has not gone to law school. At common law, B gets nothing upon A's death. That's the rule of destructibility. The modern rule would give a reversion to the grantor or grantor's heirs until grantee satisfies the condition, right? So O grants to A for life, then to B once he goes to law school. A dies and B has not yet gone to law school. It's gonna B will get nothing, right? It'll go to A to life and then revert back to O. And the modern rule is it's going to go to the grantor's heirs until they satisfy the condition, right? So once he goes to law school under the modern rule, then he would take. That's the difference in the rule of destructibility versus the common law versus the modern rule. Okay, Shelley's rule, the merger rule, to A, O grants to A for life, then on A's death to A's heirs, right? And A is alive. That's kind of weird. At common law, the remainder merges and A is a fee simple absolute, right? It would just be to O to A for life, right? And then period. It's just to A actually, because why wouldn't A get to choose who it goes to? That's the common law rule. To A for life and then to A's heirs would just be to A at common law. But the modern rule is A has a life estate and A's unknown heirs have contingent remainders. O has a reversion because A could die without heirs, right? So if it was to A to life, then upon A's death to A's heirs, the modern rule is it reverts back to O if A dies with no heirs. The common rule is it was a fee simple and it was just divided by A's estate. And then finally, the doctrine of worthier title. O conveys to A for life, then to O's heirs. The contingent remainder here in O is void. A instead has a life estate and O has a reversion, right? Because O's still alive, right? To A for life and then to O's heirs. Well, what if A dies and O's still alive? Well, it would be better to revert back to O than to go to O's heirs while O's not alive in case O doesn't like his heirs anymore. So that's the doctrine of worthier title. We're going to say it would just be to A for life and that part would be void. These are tough: merger, rule of destructibility, and doctrine of worthier title. Again, not a majorly tested area of the exam. I actually rarely see it. I'll tell you what's important. All right, executory interest. We talked about this. A future interest in a third party that takes effect by cutting short some interest. Two types: shifting and springing. includes any future interest but does not a remainder. Look for phrases but if, then to for so long as. Shifting executory interest always follows a defeasible fee. Cut short someone other than the grantor. To A for life, so long as the property is used as a storage space. But if it's used for any other purpose, to B and his heirs. A has a fee simple subject to executory interest. B has a shifting executory interest. If A stops using the property for storage, A's interest is cut short, not the grantor. Right? If it cuts the grantee's interest short, it'll be shifting. Here, springing cut short the interest of the grantor. To A, if and when A gets married. A has an executory interest. Grantor is a fee simple subject to an executory interest. If A gets married, possession springs from grantor to A. We talked about this, shifting versus springing. I think we should feel confident in that. Now let's think about something that we'll never feel confident in. Rule against perpetuities. We all got to know the definition. No interest is valid unless it must vest, if at all, no later than 21 years after the death of a life and being at the time the interest was created. So a future interest is void if there's any possibility, no matter how impossible, seemingly, that it will invest more than 21 years after the death of a measuring life. The measuring life is going to be a life and being at the time the interest was created. For imagination purposes, we should usually try and think of the youngest kid who's, tied to the conveyance or to the interest. So it applies to contingent remainders, executory interest, and vested remainder subject to open. Analyze a conveyance subject to RAP. Determine the interest being granted. Apply RAP to any interest for which it applies. And if a conveyance violates RAP, strike only the violating portion, right? If there's a executory interest or a contingent remainder that violates RAP, just strike that. You'll still keep the original conveyance. And that's what will remain. So class gifts and RAP. For a class gift to satisfy RAP, it must be closed with all conditions precedent satisfied for every member. However, the rule of convenience for class gifts may save a conveyance to a class that would otherwise violate RAP. See vested remainders. So the rule of convenience, right? It'll close when the first person reaches 21. We talked about that. Okay, here's some examples of RAP violations, and this is just the best way to understand is look at these two examples. Age contingency beyond 21. A conveyance to an open class is contingent on members reaching an age of over 21. To age children who reach 22 or who reach 30, because it's possible in the next 3 years, they'll have a kid and then it won't vest for another 27 years. It's void under RAP because it cannot vest within 21 years of a life and being at the time of the creation. Fertile octogenarian. Presumption that any woman is capable of giving birth regardless of her age. Same with men or women. You can always give birth. So a grantor conveys to A for life, then to A's children who reach age 30. A is 80, her son is 40. So to A for life, then to A's children who reach age 30. Even though they already have a 40-year-old son, it's still possible that A's son could die. She could have a daughter at 81, then die when she's 82, and the remaining daughter's interest will not vest for another 28 years. Charity exception. RAP does not apply to conveyances from one charity to another. Okay, rule against perpetuity is super tough. Let's just see if our internet friend Google can give us another example. Rule against perpetuities example. Let's see what we got. Google machine. If, for example, the last of A's children dies before the youngest of A's grandchildren reaches the age limit, no interest will vest until life plus 21 years limitation. For example, a testator leaves his estate to his grandchildren who attains the age of 21. The testator's only child, William, was born 6 months after the testator's death. William herself was only one child. Pamela was born 6 months after William's death. The will provisions that leave the estate to property are valid, and she will inherit her grandfather's estate when she reaches 21. The 21 period must be added on after the deaths of the persons or persons who are used as measuring lives. The measuring lives or life usually are persons who are named in the instrument creating the future interest, such as a will or trust. Frequently, the person whose life is used as a measuring life also has a preceding interest in the property, such as a person who has a given life estate. If the interest will not vest until after the expiration of the life or lives in plus 21 years, or there's a possibility that it might not vest, the transfer is void and fails completely. Well, that's not true. We just said that only the part of that's the rule against perpetuity will not vest. Here's some examples. O to A for life, then to A's first kid to reach 25. A has no kids 25 or older. We don't like that. There's no validating life, so contingent remainder is void. You cannot prove that A's first kid to each 25 will do so within 20 years. O to my grandkids who reach 21. T leaves 2 kids and 3 grandkids. The validating lives are tester's kid or T's kids. All of T's kids, grandkids when she's 21, if at all within 21 years after the death of T's kids. O to A for life. O to A for life, then to A's kids for their lives, then to B. Remainder to B is vested upon creation. B's remainder may vest in possession of the death of A's afterborn kids, which may be too remote, but the remainder is valid because it's vested in the interest now, right? Because it's vested. When they die, it's automatically going to transfer. So not to confuse anyone against rule against perpetuities, but I just wanted to look at some further examples. Think of the fertile octogenarian as a real good example. All right, let's go to tenancy in common. We already talked about this. An estate with multiple tenants in which each co-tenant owns an individual part and each has a right to possess the whole. The characteristics are freely transferable, no survivorship rights, and partition. A co-tenant can force partition at any time and take sole ownership of her share of the estate while the remaining parties hold their interests as tenants in common. Modern law favors tenancy in common as the default concurrent estate. Then joint tenancy with TTIP, time, title, interest, and possession. Express intent required. The grantor must expressly intend to create joint tenancy, otherwise TIC is presumed. Rights of survivorship, transferability, and severance. Severance by any joint tenant creates a tenancy in common with respect to the severed interest. Actions affecting joint tenants. Transfer of interest. A joint tenant becomes a tenancy in common. A joint tenancy becomes a tenancy in common upon transfer. This does not destroy the entire joint tenancy if 2 or more joint tenants remain. And then we talked about the lien theory versus the title theory and how that'll work. We talked about tenancy by entirety is presumed if there's 4 unions plus marriage. It can be severed by the death of one of the co-tenants, by the mutual agreements of the parties in writing, by an issuance of a divorce decree, or by execution of a joint creditor, such as a foreclosure. Co-tenants' duties, and this is a more exhaustive list, are possession. Each co-tenant has a right to possess the whole. Rent from the co-tenant in exclusive possession. Absent ouster, a co-tenant in exclusive possession is not liable to co-tenants for rent. Remember that co-tenancies give you a right to possess the whole. So you're not liable for co-tenants to rent. Rent from third parties, co-tenants who lease all or part of the premises must account to co-tenants for her fair share of rental income. You possess it as a whole. Adverse possession, tenants may not require title to the exclusion of co-tenants through adverse possession. Each tenant is responsible for his fair share of taxes or interest, etc. Repairs, co-tenants have a right to contribution for reasonable and necessary repairs, but must inform co-tenants of the need for repairs prior to undertaking. Improvements, no right to contribution for improvements, but the improvement co-tenant is entitled to credit for any increase in the value attributable to his improvement. Waste, a co-tenant can bring action for waste against another co-tenant during the life of the tenancy. And again, partition, forced sale. Joint tenants and tenants in common may bring an action for partition or seek a forced sale and apportion the proceeds. Again, with the leasehold estates, a leasehold is a estate in which the tenant has a present possessory interest in the property and the landlord has a future interest or reversion. Tenancy for years lasts for a fixed period of time, requires a definitive beginning and end. If duration is longer than 1 year, it must be in writing under the statute of frauds. Terminates automatically at the end of the fixed period. No notice is required. AKA tenancy for years, term years, tenancy for years, or fixed term tenancy. Does not need to be a year longer than a year. Any fixed amount of time which follows the above will qualify as tenancy for years. Periodic tenancy, tenancy estate that repeats until terminated, month to month, week to week. Look for periodic payments and repetition. Tenancy at will, either party can terminate anytime without notice. And tenancy at sufferance. Tenant has possession by virtue of wrongfully remaining after termination of the lease. Fancy way to say the person at lease refuses to leave. For the periodic tenancy, a leasehold that is continuous for successive intervals until either party gives proper notice of termination can be expressed implied by operation of law. Express, landlord conveys to a tenant for agreed interval. Implied, a lease does not specify duration, but provides for rent to be paid in set intervals. And by operation of law can be in two ways. Oral lease violates the statute of frauds. If an otherwise valid lease violates the statute of frauds, a periodic tenancy is established upon the landlord's acceptance of payment. Term of the tenancy is dictated by the period of rent covered by the payment. A holdover tenant, if a landlord accepts rent from a holdover tenant, a periodic tenancy is created for the period covered by the payment. Termination occurs when tenant gives proper notice. Proper notice required. So sufficient time. Notice must be given 1 year, one full period in advance. So week to week, it has to be given a week in advance. Month to month, a month in advance. In a year-to-year tenancy or longer, only a 6-month notice is required. The effective date of termination must be at the end of the period of the tenancy. A tenancy at will, no fixed duration, terminable by either party at any time without notice. You can have express agreement, and without an express agreement, the courts will treat the lease as an implied periodic tenancy. So it has to say terminable by either party at any time. Termination by will, they can either terminate it, but a reasonable demand to vacate the premises is usually required. And by operation of law, the death by either party, waste by the tenant, assignment by the tenant, transfer of title by the landlord, or lease by the landlord to a third party. So a tenancy by will is really easy to terminate. And then the tenancy at sufferance, we talked about this, the holdover tenant. A default tenancy that arises if a tenant continues possession of property after the lease is ended, a holdover tenant. Arises when a tenant wrongfully holds over possession beyond the lease expiration. The expired lease's terms and conditions automatically carry over to the tenancy at sufferance. The landlord has the option to sue, to evict, please get out of my house, or to impose a new periodic tenancy, which can include raise rent. The landlord can demand rent for both the holdover period and any new periodic tenancy if he gave notice of the increase before the lease expired. And commercial leases, if the lease expired was for more than 1 year, the new periodic tenancy can be year to year. So if for a commercial lease, you can have a holdover tenant that's 1 year periodic tenancy if the previous one was over a year. Exceptions must be reasonable for the landlord to impose a new periodic tenancy, and a new periodic tenancy is unreasonable if a tenancy only remains in possession for a few hours, the tenant is not at fault for delay in vacating because of illness or something, and seasonal leases like a ski cabin or a beach house. Right, it wouldn't be reasonable to impose more than that. Okay, tenant's duty at common law, duty to repair. Unless the lease states otherwise, the tenant must maintain premise to make ordinary repairs, not commit waste, including voluntary, permissive, and ameliorative. They have a duty to pay rent. And liability of third parties, duty not to use property for legal purposes. Remember that. And the tenant is liable for injuries sustained by third parties invited by the tenant, even if the landlord promised to make repairs. Right, so if the tenant invites over third parties who create torts, they could be liable to third parties in tort. The tenant is liable for injuries sustained by third parties invited by the tenant, even if the landlord promised to make repairs. Right, the premise liability will be the tenant. So fixtures, once movable chattel that has been attached, annexed to real property, indicating intent to permanently improve the property. Heating systems, lighting systems, if you were to shake the house, anything that remains on the wall is likely a fixture. Okay, so if you have fixtures, pass with ownership of the land. A tenant installation qualifies as a fixture if there's an express agreement between the landlord and the tenant. If no agreement, tenant may remove the chattel that tenant installed as long as the removal does not cause substantial harm to the property. If the tenant removes fixtures, he commits voluntary waste, right? You can't remove fixtures that are part of the land. Landlord's remedy for tenant breach. If tenant breaches his leasehold duties, the landlord options depend on whether the tenant remains on the premises. If the tenant retains possession, the landlord will file for notice of eviction, continue the lease, and sue for rent. If the tenant abandons the premise, the landlord may surrender, treat the abandonment as tenant surrender accepted, releasing the tenant from the lease, or the minority rule, hold the tenant responsible for the unpaid rent, and the majority rule is the relet. The lease the premise to new tenants and hold the breaching tenant responsible for any losses. Remember, there's a duty to mitigate. The landlord needs to reasonably put in the effort to find a new tenant. Important, no self-help. A landlord may not engage in self-help upon a tenant's breach. For example, forcibly removing the tenant or tenant's prolonging, changing locks, etc. Landlords' duties and warranties. Landlords have and we talked about this, the following duties to tenant: duty to deliver possession. The majority rule is actual possession. The landlord must deliver actual possession to the tenant, and the minority rule is legal possession, the right to possess. The new tenant is responsible for any holdovers on the property. So the majority rule is that the landlord has to give them the actual right to physical actual possession, where the minority rule is they only have to give them legal possession, which means, you don't have to give them actual possession as well. If there's a holdover tenant, it's not the landlord's fault. Look for case-specific facts. Implied covenant of quiet enjoyment, implied warranty of habitability, and then the tort liability that we talked about. Implied covenant of quiet enjoyment. A tenant has an implied right to quiet use and enjoyment of the premises without interference from the landlord. A breach may occur by actual eviction or constructive eviction. Actual eviction, landlord wrongfully evicts and excludes tenant from the property. Constructive eviction, landlord's action or inaction to render the property inhabitable. Substantial interference or major chronic problems. Notice the tenants must inform the landlord and give him a reasonable opportunity to repair. The landlord must fail to act meaningfully within a reasonable time, and then the tenant actually has to vacate within a reasonable time after the landlord fails to repair. A retaliatory eviction is not okay. The landlord is prohibited from retaliatory eviction if a tenant lawfully reports housing code violations. So if the tenant, reports the landlord can't evict them in retaliation. And the implied warranty of habitability. Residential must be fit for basic human dwelling, not applicable to commercial leases. Absolute duty cannot be modified by lease terms. You cannot waive this right by contract. Local code or case law may specify the standard for a breach. We're looking for no heat in the winter, no plumbing, no water, etc. Landlord's tort liability to tenants. A landlord may be liable for injuries occurring on his leased property. The landlord is liable for injuries involving common areas. Duties of reasonable care apply. The landlord must exercise reasonable care in maintaining and repairing common areas, such as the hallways and stairways. Latent defects. The landlord has a duty to disclose hidden defects he should reasonably know of. Assumption of repairs, a negligent standard. The landlord is liable for negligent repairs he chooses to undertake. A landlord hired a handyman who installed something negligently. And then public use. The landlord is liable for known defects if he knows the premises will be used by the public and the tenant is unlikely to repair, such as a concert hall or convention center. We talked about assignment and subleases. Give me a second. Sorry, I had to sneeze. Okay, assignments and subleases. So unless restricted by lease terms, a tenant may transfer his leasehold interest, either in whole assignment or in part sublease. Courts interpret lease provisions restricting sublease or assignments against landlords. The general tendency is to find a right to assign or sublease exists. An assignment, an entire leasehold transfer from tenant to assignee gives you all the months on my remaining lease. Assignee is in privity of estate with the landlord. Assignee and landlord are bound by covenant that will run with the land. Assignee remains in privity of contract with the landlord. Assignee owes rent directly to the landlord, but assigner may be liable for unpaid rent. A sublease, partial leasehold transfer from sublessor to subleasee. Subleasee is in privity of estate and contract with landlord. Relationship between tenant and landlord is unchanged. Subleasee pays rent to sublessors or tenant. Subleasee is not liable to the landlord in a sublease. Assignment sublease provisions will be construed against the landlord. Lease provisions restricting assignment or sublease are enforceable, but once the landlord gives tenant permission to assign or sublease, sub provisions are thereafter waived. I kind of wanted to go into one thing. Now that I'm looking at it, I might have actually overlooked the question we did earlier. You know me, I have to confirm. When I said that the situation between Andrew and Sam and Letty, was it a sublease or an assignment? I was going kind of fast. Oh, no, never mind. It was definitely a sublease. It was just for the summer term. If it would have been for the remaining 3 months, because it was 7 months into the lease and the summer term, that's a sublease, and literally said sublease. But an assignment would have been the remainder of the term. So I was correct. I was just making sure. Sorry about that. Okay, now we talk about some of the good stuff. Easements. Easement is a non-possessory property interest that confers a right to use another's land. Serving estate is burdened. Dominant estate is benefited if applicable. 2 types of easements. Easement appurtenant. It takes 2. Entitle the dominant estate owner to the use of the serving estate's land. Attaches to the dominant estate and passes automatically, even if not mentioned in conveyance, right? An easement appurtenant will run with the land. An easement in gross benefits an individual or entity, not a dominant landowner, to the use of the serving estate. Does not attach to the land, there's no dominant estate. The right to place a billboard on another's lot, the right to run a utility line across the land, the right to fish in another's pond. These are personal. These are easement in grosses that do not run with the land. It's similar to a license, but irrevocable and may be transferred. Affirmative easement entitles its holder to make affirmative use of the serving estate, and a negative easement entitles its holder to restrict the serving estate from otherwise permissible activities. The creation, easements may be created by prescription, necessity, implication, or expressly by grant or reservation. Easement by prescription, similar to acquiring title for adverse possession minus the last element. There's no need for exclusivity because multiple people can have the same easement where only one person can have title. So ocean without the E. Open, continuous, notorious, hostile. For the applicable statutory period, which we're going to assume is going to be 20 years on the MBE. Same with adverse possession. We assume 20 years for both of them. Open and notorious, owner knows and should know the use. Hostile, without the owner's permission. Easement by implication. An easement legally implied based on prior use by a common grantor on a tract of land subsequently divided into multiple plots. The requirements. The easement exists prior to division of a single tract. The common grantor's use is continuous and apparent. Use is reasonably necessary for enjoyment of the dominant tenement, and the parties intended the use to continue after the division of the land. So it's based on prior use by a common grantor on a tract of land that was subsequently divided into multiple plots. It will be implied that there's an easement now. And then easement by necessity. An easement can occur if access to or from a property is impossible without the easement. Very high standard. Usually arises when a landowner sells a portion of his or property and the resulting division deprives one lot owner access to a public road or utility. The owner of the serving estate can choose a reasonable location for the easement. The termination. The easement expires automatically when the necessity ends. Express easement. Easement by grant or reservation. Easements may be expressly created by grant or reservation, and a grant is an express grant of an easement. A grantor conveys title to land but reserves the right to continue using land for a designated purpose. That would be an express easement. Scope of easements. An easement scope is determined by the terms or conditions that created it. Just like in contract law, we're always going to look to this. Just give me a second. I'm going to plug in my charger. But yeah, an easement can be expressly created, and the terms of the easement can be explicit and governing. So easement holders cannot unilaterally expand the scope of their easement, for example, through use or misuse. Do what's allowed in the easement, but if you overuse it, then the remedy for that will be an injunction. Overuse or misuse of an easement does not terminate an easement. The serving owner's remedy is an injunction. Duty to repair. Easement holder has a duty to make repairs if he is the sole user. If both the servient landowner and the easement holder use an easement, the repair costs are apportioned. I've actually seen that in case law. When I was actually an intern for this firm, Picard Iverson, where my uncle is a partner. Great law firm. Okay, terminations of easements. Easements may be terminated in any of the following ways. Estoppel arises if the owner reasonably believes on an easement's holder's conduct or misrepresentations, indicating an intent to abandon the easement. Mere non-use is insufficient. If the necessity ends, Easement by necessities expire when the need that created the necessity ends. This applies to easement by necessity only. The end of a necessity will not terminate other easements. Destruction of servient tenement. Unless destruction results from willful conduct of the servient owner. So if the servient tenement is destroyed, then unless willfully by the servient owner, then that will terminate the easement. Release. The easement holder can terminate the easement by giving a deed of release to the servient tenement owner. So the easement holder, not the tenement owner, the holder, not the servient owner, the dominant holder can release. And abandonment. An easement holder may terminate an easement by physically demonstrating a clear intent to permanently abandon the easement. Mere words or non-use are insufficient. Merger. An easement will terminate automatically if the same person acquires title to both the easement and the servient land, obviously. All right, the difference between a license and a profit, we want to talk about this. A license is a privilege to enter another's land for some delineated purpose, not an interest in land. Think of your concert tickets, which gives you a license to enter a music venue. Licensor may revoke the privilege at any time. No statute of frauds requirement. A license may be oral or written. No alienability. A license is not transferable because there's a privilege personal to the license holder. Whereas a profit is a non-possessory interest in land which entitles its holder to enter a serving estate and take some resource from the earth, such as soil, timber, or fish. All the rules governing easements apply to profits: creation, transferability, and termination. Right. Even like a profit is a true right to a property. Even if there's a taking and you had a profit, you'll be subject to just compensation. A profit may be extinguished through misuse or overuse of resources on the serving estate. So a license is a privilege. A profit is an interest to take some resource from the land. Covenants. So we're going to talk about covenants versus equitable servitudes. Look at the main difference being the remedy. Equitable servitudes will provide injunctive relief, equitable relief, and covenants will provide legal relief, money damages. So a covenant is a promise to do or refrain from doing something related to land. A contractual limitation or promise regarding land, a covenant is not a property interest. It's a limitation or promise. A real covenant is a covenant concerning real property. This runs with the land at law. Subsequent owners may enforceably be burdened by the covenant. Different requirement applies for the burdens and benefits running with the land. We'll talk about that. It's going to talk about the privity requirements. Restrictive covenant, a promise to refrain from doing something on the land. An affirmative covenant, a promise to do something related to the land. A restricted covenant, I promise not to have any trees on my front yard. A affirmative covenant, I promise to paint my door blue. At my townhouse in Coconut Grove, I have a covenant to paint my door blue. I guess we're trying to be like Greece or something. Termination can occur by written release, merger of benefit and burden estates, and condemnation of the burden property. So we talked about the main difference between equitable servitudes and covenants is the remedies, covenants by damages, equitable servitudes, injunctive relief. Okay, so if we want a covenant to run with the land, remember there's a difference between the burden and the benefit, and we're going to zero in on this. So what are the necessary for the burden of the covenant to run with the land? A successor and an interest of the burdened estate. And when we tell the burdened estate, the one that actually is restricted from doing something, will be bound by the covenant. The following conditions are satisfied. And always going to have the same. We're always going to have the same three at the top: writing, intent, and touches and concern to land. Writing, the original covenant was writing. Intent, the parties intended to bind their successors in interest. Look to language of the covenant. Courts are liberal in construing requisite intent. Touches and concern to land. Covenant must affect the parties' legal relation as landowners, a very low standard. Homeowners association fee satisfies this requirement. Now, for it to be the burden, we're going to have horizontal and vertical privity. Must exist between the interested parties. Horizontal privity is a relationship between the covenanting parties, the grantor grantee, the landlord tenant, and the mortgagor mortgagee. Whereas vertical privity is going to refer to a relationship between the covenanting parties and their successors in interest, contract, devise, or descent. And then notice, the successor in interest had notice of the covenant when she took her interest. That's necessary for the burdens. What's necessary for the benefits of a covenant to run with the land are writing intent, touch and concern of the land, and then only vertical privity. We don't need horizontal privity. So successors in interest are in vertical privity with the original covenanting parties through contract, devise, or descent. And then equitable servitude, for an equitable servitude to run with the land, it's actually a lot simpler. For an equitable servitude to run with the land, we just need writing, intent, touching and concern of the land, and notice. There's no need for privity when we have an equitable servitude. So to reiterate that, if it's going to be a real covenant to run with the land and it's the burden, we're going to need horizontal and vertical privity and notice. If it's going to be benefit running with the land, we just need vertical privity. And if it's going to be an equitable servitude, we need writing, intent, touches and concerns of the land, and notice. So we don't need any privity for an equitable servitude. Okay, reciprocal negative servitudes. Each lot owner in a residential subdivision may enforce a restriction on the use of property against every other owner in subdivision. And this can be implied from a common development scheme or of a residential subdivision. All houses in the residential area are painted in yellow. Look for that common scheme or plan. Created through implication if general common scheme. At the time sales began, the developer had a general scheme for all parcels of the subdivision, including the subject lot. The common scheme may be evidenced through recorded plat, general pattern of restrictions, or representations to early buyers. And then notice, the owner of the subject lot had notice of the covenants and deeds of other subdivision lots. And this is important for just life. There's 3 different types of notice. There's actual notice where you literally can say you had notice, like it's proven. There's inquiry notice where you should have looked around and figured it out. And then there's record notice where it's been recorded. Chain of title for the owner's lot includes a prior deed containing covenant. So inquiry and record notice are going to be constructive notice, whereas actual notice is going to mean you actually had notice. And that'll be important when we do talk about notice in the notice statutes. So adverse possession, a trespasser may acquire title to another's property without compensation by possessing the property for a specified time period in a manner conflicting with the true owner's rights. The requirement, the trespasser's possession of the land must be, I remember this, open, continuous, exclusive, adverse, and notorious. Continuous for the statutory period. Continuity of possession must be similar to how an ordinary owner would use the property. Daily possession is not required if an ordinary user would not use the property daily, like a winter cabin or summer beach home. And continuous possession must last for the statutory period. Open and continuous. Trespassers' use of the property must be out in the open such that the true owner would know of the trespass if he inspected his property regularly. You just can't come out every night between 3 to 5 a.m., but otherwise live there. The owner need not actually know of the trespasser's use. So actual and exclusive, the trespasser must actually possess a reasonable portion of the property to the exclusion of the true owner and the public. And then hostile, the possession must be without the owner's permission. Look for that. No knowledge or intent requirement. Trespasser need not intend to adversely possess. And then tacking. An adverse possessor can tack together successive periods of adverse possession, even if by different adverse possessors, to satisfy the statutory period. Must be successive. There cannot be gaps between periods of adverse possession. Okay, now we can talk about land sale contracts and conveyancing. Land sale contracts are subject to the statute of fraud and must be in writing, signed by the parties to be bound, articulate the essential terms, consideration to be paid, and description of the land. Exception, partial performance. A land contract sale is outside the statute of frauds if the buyer takes possession and either pays all or part of the purchase price, makes substantial improvements, or possesses the land. Okay, so how does the land sale process work? Well, we're going to have a contract, an agreement to buy and sell the land, an escrow period, transfer funds through escrow, closing, escrow completion to deed transfer, and a conveyance, successful deed transfer upon which property is conveyed to the new owner. Equitable conversion and risk of loss in land sale contracts. We talked about this. Equitable conversion. During escrow, after land sale contract, but before deed delivery, the buyer owns the real property, but the seller owns their personal property. So the seller is the holder of legal title and trust for the buyer. the risk of loss. If the property is destroyed before closing through no fault of the parties, the buyer bears the risk of loss. The parties can contract differently. The seller must credit any insurance proceeds from loss against the purchase price. Implied promises in land sale contracts, marketable title and statement of material facts. So these are implied in land sale contracts. Every land sale contract must contain the two implied promises: promise to provide marketable title and promise to make no material false statement and disclosure. So the promise to provide marketable title is the promise that the title is free from risk of litigation. Defects rendering title unmarketable include if it's acquired by adverse possession. Keep that in mind. It's not marketable if it's acquired by adverse possession. Undisclosed unencumbered interests, for instance, servitudes, mortgages, future interests. Note that upon closing, the seller has the right. Note that upon closing, the seller has the right to satisfy outstanding mortgages or liens with the proceeds of the estate. So note that upon closing, the seller has the right to satisfy outstanding mortgages or liens with proceeds of the estate. Meaning if there's a mortgage on the property, but you're going to use the proceeds of the sale to pay off the mortgage, then that's actually not going to be an undisclosed encumbrance. And then zoning ordinance violations existing at the sale. If you're a few inches away from the setback, that would be a zoning violation. Promise to make no material false statement and disclose. So we definitely want to keep these in mind. So the seller must not make material misrepresentations or false statements concerning the property. The seller must disclose latent material defects. The seller cannot limit liability through disclaimers. And for new property, the seller buyer is subject to an implied warranty of fitness / quality of construction. So for new property, the seller's builder is subject to an implied warranty of fitness / quality and construction. The remedy for breach: the buyer must notify seller before closing and give reasonable time for seller to cure defects. If the seller fails to cure, buyer can rescind, file for damages, demand specific performance, or file suit to quiet title. If buyer fails to notify the seller before the closing, the contract merges with the deed and the seller is not liable. Remember the merger doctrine. If you fail to sue on the contract before the closing, then you can only sue on the deed. So deeds: a deed passes legal title from seller to buyer. A deed must be lawfully executed. The deed must be signed by the grantor and must reasonably identify the parties in the land. Delivered: requires intent to be bound by the conveyance. Title passes upon effective delivery. It cannot be rescinded. Present intent is determinative. Physical transfer is not required. Focus on the person's delivery intent. And acceptance: grantee must accept the deed. Acceptance is usually presumed upon valid delivery, unless you explicitly reject it. Like, I don't want that deed. Take that away from me. Otherwise, it'll be presumed to be accepted. 3 types of deed we talked about: general, special, quitclaim. General warranty deed has 6 covenants. Special warranty is only for the time you had title to it. So he has not conveyed this land to another, and the land is free from encumbrances made by the grantor. And then quitclaim, no covenants included. The grantor is not even promising he has title to convey. Quitclaim deed is like a shotgun sale, like just take it. So we talked about the present covenants for the covenants of seisin, right to convey, right against encumbrances. Seisin is the grantor covenants that he is the rightful owner, he has title and possession, and that the deed covers the described land. The right to convey: the grantor covenants that he has the right to convey. Against encumbrances: the grantor covenants that the land is free from encumbrances, servitudes, or mortgages. These are only available at the time of delivery. You can't sue 6 months later. 6 months later, you would have to sue for the future covenants, which would be quiet enjoyment. The grantor covenants that grantee will not be disturbed by a third party's claim of lawful title. Warranty: the grantor agrees to defend against lawful claims of title by another. And further assurances: the grantor promises to perform future acts reasonably necessary to perfect the title conveyed. Okay, a bona fide purchaser is someone who takes for value without notice. A BFP purchased property for value, pecuniary consideration, without notice of a prior conveyance. So if someone's just gifted a property, they're not a bona fide purchaser. They have to take for value. Purchasers include mortgages for value. does not include donees, heirs, and devisees, not protected by the recording statutes unless the shelter rule applies. The shelter rule will state that you could take downstream protection in that a downstream holder can take upstream status of a holder in due course, meaning if someone pays for a property and becomes a holder in due course and then gifts it to the next person, that subsequent person is still a holder in due course under the shelter rule. So we talked about the different types of notice. A buyer has notice of a prior conveyance by actual notice. They actually know about it. Inquiry notice, what a reasonable inspection of the land would reveal, regardless of whether they actually inspect it. And then record notice is knowledge obtained from a routine title search. A previous deed, conveyance, property is recorded. So that's record notice when it's recorded. Now we talk about the recording statutes. And remember, they'll tell you what type of recording statute it is. If a prior conveyance or interest is not recorded, a subsequent purchaser / mortgagee may be protected under the recording statute. The level of protection depends on the type of recording statute. Notice statute, pure notice, a subsequent bona fide purchaser always prevails. A subsequent bona fide purchaser always prevails whether or not she recorded first over a prior grantee who fails to record. Sample language. No conveyance or mortgage. So this is what they'll do on the MBE. They'll give you sample language. They won't tell you it's a pure notice. They'll give you the language, and then you'll have to know, oh, this is a pure notice statute. This person will prevail because they're a bona fide purchaser. No conveyance or mortgage of interest in land shall be valid against any subsequent purchaser for value without notice thereof unless is recorded. That word without notice, notice statute. Race notice, some subsequent bona fide purchaser who prevails first. Race notice is a combination. You have to be a BFP and first to record. No conveyance or mortgage of an interest in land shall be valid unless any subsequent purchaser for value without notice, notice statute, thereof whose conveyance is first recorded, race statute. So that's a combination. Race statute, regardless of whether the buyer is a BFP, so they can be given it, the first grantee to record prevails. Non-BFP purchaser who records first prevails over BFP. Race to record. Sample language. No conveyance or mortgage of an interest in land shall be valid against a subsequent purchaser whose conveyance is first recorded. Chain of title problems, shelter rule, wild deeds, and estoppel by deed. Several issues can arise concerning recording statutes and chain of title. Shelter rule, a person who takes from a BFP will prevail against any interest the transferee BFP would have prevailed against, even the transferee had actual notice of a prior conveyance, right? Even if they had notice or even if they took without value, they still can be a BFP based on the shelter rule. Wild deeds, a recorded deed unconnected to the chain of title due to a clerk's filing error, that's called a wild deed. And then estoppel by deed. Be careful to look at this one. This always comes up on the test. One who conveys land in which she has no interest is stopped from denying the validity of that conveyance if she subsequently acquires the same interest that she had previously transferred. Prevents one from fraudulently conveying land and later validly acquiring it. So A transfers land to B. A doesn't own the property. Later, A inherits the property. That will pretty much validate the earlier conveyance, and I'll be stopped from denying it. So it'll actually go right to B. On the moment I inherit it, it'll go to B because I had previously transferred it. That's estoppel by deed. Okay, mortgages. A mortgage is a security interest in land that serves a collateral for the repayment of the loan. So it could be called a mortgage deed, a security interest in the land. It must be in writing to satisfy the statute of fraud. The mortgagor is the one who takes out the mortgage, the debtor, the borrower, the landowner, and the creditor, the bank, is the mortgagee. So under the majority lien theory, a mortgagor has title and right to possession absent foreclosure. A mortgagee cannot take possession prior to foreclosure. A mortgagee has a lien, conferring a right to take action for ownership of land if the mortgagor defaults on the loan. The mortgagee can take possession at any time before closure. Remember, under the minority title theory, the mortgagee has title to the property during the loan term, not the mortgage or borrower. On the MBE, assume lien theory applies. So we know what a mortgage is. A mortgage is you take out money and the security is the house. Now, if it's a PMM, a purchase money mortgage, that's going to have the highest priority. So a mortgagee, a creditor, can transfer interest by endorsing the mortgage note and delivering to the transferee interest. So a holder in due course. A holder in due course takes a mortgage note free of any personal offenses the mortgagor could have raised against the original mortgagee, such as lack of consideration fraud. He still remains subject to the real offenses, fades, fraud, alteration, incapacity, infancy, illegality, insolvency, duress, statute of limitations. Requirements are holder in due course. Negotiable note, the note must be negotiable, made payable to the named mortgagee, endorsed and signed. Note must be endorsed or signed by the named mortgagee. Delivered, note must be delivered to the transferee, and good faith and value paid. Transferee must take the note in good faith without notice of illegality and pay value. So we see a lot about that becoming a holder in due course and how that'll give you some extra rights. Okay, so let's talk about a foreclosure. Upon default, the mortgagee can satisfy debt through a foreclosure by judicial action. The property is sold to satisfy the debt in whole or in part. A deficiency judgment. So when we have a foreclosure, that's for the senior priority, and it's to pay them off. All the junior mortgages will be, they won't be able to take. They'll have to file deficiency actions. Deficiency judgments are for junior mortgages and junior mortgagees, and for if it's not enough, if the loan is more than the value of the house. So upon default, the mortgagee can satisfy debt through foreclosure by judicial action. Property is sold to satisfy the debt in whole or in part. Deficiency judgment, if proceeds from the sale are less than the debt balance, the mortgagee can bring a personal action against less than the debt balance, or if they're junior mortgagees. If proceeds exceed the debt balance, junior liens are paid in order to their priority. Redemption and equity. At any time prior to the foreclosure sale, the mortgagor can redeem the property by paying the amount due. That's called a redemption equity. Some jurisdictions allow the mortgagor for a certain period to buy back the property after a foreclosure sale. That's called statutory redemption. Equitable redemption is that the mortgagor can buy it back. Think of like Happy Gilmore, when his grandma was selling the house, he wanted to buy it back. That's a equitable redemption. We're going to think of statutory redemption in some jurisdictions after the foreclosure sale. So then we could talk about priority of creditors. Creditors must record their interest. Recorded interest take priority in their order recorded. So PMMs, like I said, are superior to all interest. A purchase money mortgage is a mortgage given in exchange for funds used to buy the property. A purchase money mortgage is given either to the seller as part of the purchase price or a third-party lender. If both, the seller's PMM is senior to the third-party lender. A creditor can agree to subordinate her priority to a junior creditor, right? If it's explicit, you can agree to it, but usually the PMM is going to have senior priority. Look for that answer. Junior interest, like I said, are terminated by a foreclosure of a superior claim. Foreclosure terminates all junior interest, and the junior interest holders cannot look to the land to satisfy the debts. Junior interest holders can seek a deficiency judgment against the debtor, ensuring the debtor remains liable for the balance of the junior mortgage. Junior interests are necessary parties and must be included in a foreclosure action. Make sure you take note of that. Otherwise, the junior mortgage will remain on the land. So if there's a foreclosure action, the junior interests are necessary parties. Senior interests are unaffected by junior interest foreclosures. A buyer at a foreclosure sale takes property subject to senior mortgages. The buyer is not liable for senior debt, but the senior mortgage remains on the land. Something I just want to mention about mortgages is you could take subject to or expressly assume a mortgage. If you expressly assume a mortgage, then the original mortgagor is going to become secondary liable. If you take subject to, then the original mortgager is still going to be primarily liable. You have to expressly assume it to relieve the original mortgager from primary liability. Okay, lateral and subjacent support. Lateral support. Ownership of land includes the right to have land supported in its natural state by adjoining land. Landowners can be liable for their excavations that cause damage to adjacent land. P can bring claims. Negligence. If an adjacent landholder's excavation causes damages to land improved by buildings, the excavating owner is only liable if he acted negligently. And then subjacent report. Underground subadjacent structures must support surface structures existing when the subjacent estate was created. Subjacent owners are strictly liable for failure to support pre-existing surface structures. Negligence standard applies for subjacent structures erected prior to surface structures. Subjacent structures include parking garages, tunnels, mines, etc. So basically, you have the right, of your property not to be impacted to the right or to the left. Water rights, riparian rights, land bordering water courses, natural artificial bodies of water, lakes or rivers is governed by either the Riparian Doctrine or the Prior Appropriation Doctrine. Excuse me one second. And there's 3 different theories for riparian doctrines: reasonable use theory, natural throw theory, and prior appropriation theory. So I'm sorry, we have the riparian doctrine, which is going to refer to water rights, reasonable use theory. Riparian owners share rights to reasonable use and are liable to other owners if their use unreasonably interferes with other owners' use. Compare utility of use versus gravity of harm. Natural flow theory. Riparian owners may be enjoined for any use resulting in a substantial material reduction, otherwise quantity or quality, and natural use prevails over artificial uses. So for water rights, basically, whoever was using it, you're going to be allowed, just like the water behind me, to use it in its natural state. Prior appropriation doctrine. Water rights are acquired by actual use. Priority of beneficial use determines rights to water. The first individual to make beneficial use has a superior right to its use. And then water rights in groundwater and surface water. Groundwater, water beneath the surface is not confined to a known channel, like water in wells. Surface water, surface owners entitled to make reasonable use of groundwater, but must not be wasteful. Surface water, water from rain, springs, or other runoff that has not yet reached a natural water course. Landowners can generally use surface water as they please, but may be liable for interrupting its flow. Liability depends on which theory is applied. Natural flow theory, owners can not unreasonably alter natural drainage. Common enemy theory, owners can do anything to change drainage or combat flow unless it causes unnecessary damage to other land. And the reasonable use theory, the utility of use is balanced against the gravity of harm from that use. And then we talk about variances, non-conforming uses, and amortizations. I talk about this in con law too, but pursuant to its police powers, governments may enact statutes to reasonably control land use. Cities and countries must be authorized to do so under an enabling act. Zoning ordinances must be reasonably related to the public welfare, not too restrictive and not racially discriminatory. So variances is when you're applying to do something different. Government position to be exempt or vary from literal restrictions of a zoning ordinance. To qualify for a variance, a landowner must show undue hardship and that the variance will not negatively impact the surrounding properties. A non-conforming use means you're grandfathered in. Once lawful existing use for a property is now deemed non-conforming under the new zoning laws. The government cannot eliminate a use all at once unless just compensation is paid. Government may provide the landowner with an amortization whereby the government will make payments to the landowner over a set period of time until the landowner recoups the value of the non-conforming use. So amortization means you're slowly going to stop doing something. And then finally, special use permits and exactions. A special use permit applies to properties requiring a permit, even though zoning allows for the intended use, usually hospitals, funeral homes, drive-thrus, etc. And then exactions, a condition for receiving governmental developmental approval. This condition is usually payment or contribution of property to government to offset the private development demands on government infrastructure or public services. Due to population increase from a new housing development, government will have to install new bus stops and traffic lights in surrounding areas. The government can seek exaction of payment from the developer. The requirements are a nexus and proportionality. There must be a rational relationship between the exaction sought by the government and the burden on public facilities, and proportionality. The exaction must be reasonably related in nature and scope to the impact of the development. So thank you all for bearing with me through that 31-page outline, but I wanted to make sure we left no stone unturned. And I think it's really important to hear every element from the outline because, we don't want to miss everything. So you can listen to this over and over. The last exercise that we're going to do is I'm going to go over my cram guide with you, which is strictly just reading answers from and explanations from previous MBE questions so you can start to recognize the pattern. And I think between the PowerPoint, the outline, and the cram guide, this lecture should be extremely valuable to students taking the bar exam. I'm actually admitting a student right now who's going to listen in on what we're saying. So welcome, EJ. Welcome. I'm just reading over the cram guide, and then we'll talk about your individual course. But this is very important. This is real property cram guide, and these are answers and explanations, and it's about that repetition of hearing these answers. So let's just read through these, and then we'll call it a nice day. So rule against perpetuities. No interest invalid unless it must vest at all, no later than 21 years after some measuring life of the creation of the interest. A license is a permission to use the land of another. It is revocable and not subject to statute of frauds. For example, if someone has a license to use someone else's land but then sells the property, the new owner could revoke the license. A profit, short for profit à prendre in Middle French for the right of taking in the law of real property, is a non-possessory interest in land, and like the better known easement, it gives the holder the right to take natural resources such as petroleum, minerals, timber, and wild game from the land or the other. So we can differentiate profit versus license because a profit actually is an interest in the land where a license is merely a possession. A deed must properly identify the grantor and grantee to be effective. A deed that does not identify the grantee is ineffective until the grantee's name can be added or determined. An appurtenant easement passes with the dominant estate. Easements are terminated by release or abandonment. The holder of an easement has a right to use a tract of land called a servient tenement for a special purpose, but has no right to possess and enjoy the tract of land. The owner of the servient tenement continues to have the right to full possession and enjoyment of the land, subject only to the limitation that he cannot interfere with the right of special use created in the easement holder. That's an interesting one. So the holder of the easement has a right to use a tract of land called a servient tenement for a special purpose, but no right to possess and enjoy the tract of land. An easement can be destroyed by merger. If ownership of the two comes together in one person, the easement is extinguished. For the merger to be effective, complete unity is required. This means that the duration of the servient tenement must be equal to or longer than the duration of the dominant tenant with which it is combined. If complete unity is required, then the easement is extinguished. So this is merger, how we can destroy an easement if basically you come up owning the two properties and they come together. Real estate contracts require the seller to convey a marketable, also known as merchantable title. If the contract is silent on the issue of what kind of title is to be conveyed, the obligation to convey a marketable title will be implied in the contract. Marketable title is free from reasonable doubt as to both matters of fact and law, and a reasonable person will be willing to accept it readily. We talked about this. Parties can contract for something less than marketable title. Quitclaim deeds transfer whatever title the grantor has to the grantee, even if the title is unmarketable. However, unless the parties specifically contract for this kind of conveyance, there will be an obligation to convey marketable title. After the closing, the deed typically replaces the real estate contract as the embodiment of the parties' relationship, the doctrine of merger. Most obligations imposed by the contract of sale are discharged unless they repeat in the deed. For example, if a purchaser contracted for merchantable title but accepts a quitclaim deed, the purchaser would not be able to sue on the contractual provisions if the title turns out to be defective. The purchaser in this scenario would be limited to provisions of the deed. Thus, real estate contracts are only relevant during the gap between its signing and the delivery of the deed. All tenants in common hold an individual undivided ownership right in the property. This means that each party has the right to alienate or transfer the ownership of her ownership interest. This can be done by deed, will, or other conveyance. The interest in a tenancy in common need not be equal. A tenancy in common may bring an action to partition the property. Partition in kind, in which there's a physical division of the common property, is preferred. However, partition by sale is allowed when a fair and equitable physical division of the property is impossible. Upon partition of the property, each co-tenant will receive either ownership ratio of the land in the partition in its kind, in which case the land is physically divided, or the ownership ratio in the proceeds of the partition by the sale. Partition is when the co-tenants just want to break up the property. A judgment lien is a court ruling that gives a creditor the right to take the possession of a debtor's real property if the debtor fails to fulfill his or her contractual obligations. A judgment lien may be made against an individual or business and allows a creditor to access the debtor's business, personal property, and real estate, among other assets, to pay the judgment. A plaintiff who obtains a monetary judgment is described as a judgment creditor, while the defendant becomes a judgment debtor. So that's a judgment lien, and it's a court ruling that gives the creditor the right to take possession of a debtor's real property if the debtor fails to fulfill his contractual obligations. Good terminology. The dedication of land for public use requires two elements: dedication and acceptance. Under common law, an offer of dedication may be made by a written or oral statement. the submission of map or plat showing the dedication, the opening of the land to public use, acceptance can occur by a formal resolution, the approval of the map or plat, and the actual assumption of maintenance or construction improvements. So a dedication is giving away land for public use, and it needs to conform with those formalities. Only bona fide purchaser are entitled to prevail against a prior transferee under a notice or race notice recording statute. We talked about these statutes. To attain the status, the person must be a purchaser or creditor, take without actual constructive or inquiry notice of the prior instrument. Remember, actual, you really have notice of it. Constructive is going to be record notice, and inquiry notice means you should have looked around, and pay valuable consideration, so for value. If these requirements are not met, the person is not protected by the recording acts, so the common law rule of first in time, first in right prevails. If one owner has implied easement over a part of another's property, that owner has a right to provide repairs on that property that's part of the easement. A common staircase, for example, since he relies on the safe maintenance of the property. So I've actually dealt with this in practice, but it's like you have an easement, who's supposed to pay for it? The rule is if only the one person is using it, like the dominant estate, then they have to pay for it. If both parties are making use of it, then they have to apportion the cost of repairs. That's the general rule. There's a difference between a right to sell agreement and a right to list agreement. I somehow get these questions wrong a lot in the MBE. I think it's because realtors kind of are dime a dozen in my life. There's a difference between a right to sell agreement and a right to list agreement with a realtor. A right to sell means that if the home sells during that period, the realtor is entitled to commissions. Right to list implies that an open listing and the homeowner could sell the house themselves without giving the realtor commissions. So if they only have a right to list, that still gives the owner the right to sell the property themselves without giving the realtor commissions. If it's a right to sell, then no matter who sells it, they're getting their commissions. So if you're a realtor, you want to get that right to sell. A ticket to a concert or a sporting event is a license but not a property interest, and therefore can be revoked by the owner of the building. The proper remedy for a ticket breach would be a contract claim, not a property claim. A private nuisance is an unreasonable and substantial interference with the landlord's use and enjoyment of the land. We talk about that in torts as well. To make a claim for private nuisance is the same as it is in torts, because it's the same. The plaintiff has the burden to show the three elements. The plaintiff has a possessory interest in the land. The defendant performed an act that interfered with the plaintiff's use and enjoyment of the property. The defendant's interference with the plaintiff's use or enjoyment was substantial and unreasonable. Remember, if it's the daytime and you are nocturnal, so you sleep during the daytime, you can't have a nuisance claim for noise because it's not, you're overly sensitive, and that's the case. So 3 types of statute: notice, race notice, race notice. We're looking for the language, and it's always, if it's notice, you're looking for without notice. If it's race notice, without notice, first to record. If it's race, it's just first to record. Under pure race, whoever records first wins. Notice is irrelevant. If it's pure notice, it's going to be the BFP. And if it's race notice, subsequent BFP is protected only if she records before the prior grantee. The operative words are without notice, first recorded. Statute of frauds requires a contract for the sale of land to identify the parties, contain a description of the land, evidence of intent to buy and sell, recite usually a price term, and be signed by the party against whom enforcement is sought. Title does not have to be marketable until the closing date when all payments have been received. An equitable servitude is a covenant that, regardless of whether it runs with the land at law, equity will enforce against the assignees of the burdened land who have notice of the covenant. The usual remedy is an injunction against violation of the covenant. Generally, equitable servitudes are created by covenants contained in writing that satisfies the statute of frauds. As with real covenants, acceptance of a deed signed only by the grantor is sufficient to bind the grantee as a promisor. Remember, equitable servitudes, we're not going to need that privity for it to run with the land. If it's a real covenant and it's the burden running with the land, we're going to need horizontal and vertical privity. If it's just the benefit running in the land, we're only going to need vertical privity. An equitable servitude in a deed is only enforceable where a party can establish intent that the restriction be enforceable by subsequent grantees, that the subsequent grantee had notice of the servitude, that the restriction touches and concerns the land. Unlike restricted covenant, privity is not required. And remember, privity is different between burden and benefit for restricted covenant, burden requiring horizontal and vertical privity. Horizontal privity be privity amongst the original parties, and vertical privity being party amongst subsequent parties. Okay. An assumption of a mortgage makes a buyer primarily liable for any deficiency. So we talked about that. Assumption of a mortgage versus you expressly assume, that's assumption, versus subject to. If you just take subject to, then the buyer is not going to become primarily liable. The original mortgager will still be primarily liable. In this assumption mortgage, the original mortgagor will still be secondarily liable unless there's some explicit like wording. Remember, contract law, real property, all these things that are essentially contract law, the express terms of the contract will usually dictate unless there's some crazy reason that it's like against public policy. Don't be nervous to read the contract as it's written. Okay, the life tenant is held liable for the remainder man for any waste during his or her life tenancy. A tenant, so with the life tenancy and the remainder man, I think I clarified this, but to reiterate, the life tenant has to pay the taxes and the interest, and the remainder man has to pay the principal of the mortgage. Okay, the life tenant is held liable to remainder man for any waste. We talked about actual waste, like you mess with the property, permissive waste, you let it go to waste, you let it rot, and then ameliorative waste, you actually improve it, but still waste. A tenant who remains in possession of a leased property wrongfully past the expiration date of the lease creates a tenancy at sufferance. When a tenancy at sufferance comes into existence because of a holdover, the landowner has the right of election between evicting the tenant, holding the tenant to another term. If the landowner elects to hold the tenant to another term, most courts hold that a periodic tenancy is created. In a commercial lease, if the original lease was for more than 1 year or more, a year-to-year tenancy results from a holdover tenant. In a year-to-year lease, all conditions and terms of the tenancy are carried over from one period to the next. There are 4 elements that must be met for a covenant to run with the land at law: touch and concern of the land, privy of estate, notice, and intent. A determinable estate is an estate that in land that automatically comes to an end when the estate event occurs or fail. We beat this into a bush today. There's fee simple determinable, where it's going to automatically revert. There's fee simple subject to condition subsequent, where you're going to have the right of reentry. And then there's fee simple subject to an executory interest, where you're going to have a third party. So a determinable estate automatically comes to an end when a estate event occurs or fails to occur. The limitation gives a grantor control over the use of the property, even after the grantor has died or the property has changed hands. By definition, the creator of a terminal estate is left with an estate known as the possibility of reverter. To create a terminal estate, the grantor needs to use durational language. Words used to create terminal estates are generally ones that make it clear the estate is durational. Just as a fee simple may be defeasible rather than absolute, a life estate can also be constructed as defeasible. As with defeasible fees, a life estate can be sold or transferred to a third party. However, since a holder cannot transfer more than he or she owns, the buyer recipient will have to surrender the land upon the death of the person who was the measuring life of the original life estate. So if you give it to me for life, I can, let my brother live there. But once my life ends, and I keep telling myself not to use myself as the measuring life, but here we are. There are 2 types of vested remainders: those that are simply vested in one person or class, and those that are vested in a class whose members may not be fully discernible, referred to as a vested remainder subject to open, sometimes called a subject to partial divestment or subject to partial defeasance. I've gotten that wrong before because I didn't realize divestment and defeasance mean the same thing in the MBE. A class is subject to open where there's a possibility for more people to become members of the class in the future. No matter how factually unlikely, a class of children is subject to open unless their parents are dead. The only requirements to be met for a conveyance of land to be valid and thereby transfer legal title on the land from one party to another are execution, delivery of the deed. The execution requirement is satisfied as long as the deed is signed by the party to be charged, the seller or transferor, and delivery of the deed is established by a proven intent to pass title, even if the title document was never physically given to the grantee. The grantee's acceptance of the deed will be presumed unless the grantee explicitly rejects it. So look for that. They have to explicitly be like, nah, I don't want this deed. If they just take it or they say nothing, then it'll be assumed to be accepted. With regard to defects in a property, sellers are required to disclose all known defects that will be not open and obvious to a buyer and are prohibited from concealing such defects in any way. This is going to be Johnson v. Davis from Florida. It's a general rule that a specific devise will be deemed if at the testator's death, the testator no longer possessed an interest in the property, devise, and no contrary intention is set forth in the will. A deemed is when the thing no longer exists. Abated is when it's diminished. A judgment, note, or mortgage lien given by one joint tenant on his interest in property is not severed the joint tenancy, because we assume on the MBE we're a lien theory state. If this was a title theory state, it would indeed sever the joint tenancy, and they'll tell you that in the fact pattern. A signature is not required in order to show mutuality or assent to the terms of a writing. Assent can be shown in other ways, such as the party's conduct. It's kind of general contracting. A purchase money mortgage, PMM, executed at the same time as the purchase of the real property encumbered, takes precedence over any other claim or lien, including a previously filed judgment lien. Right? PMMs are always going to win out. A mortgage is a security for the performance of an act. The performance may be by the mortgagor or by some other person. The doctrine of estoppel by deed, I mentioned this comes up every single test, is going to be where A transfers to B when A didn't have the authority or title to transfer, but later A gets that authority or title, it'll reactivate the validity of the conveyance and B will receive. The doctrine of style by deed, sometimes referred to as after acquired title, they're synonyms, provides that even if the grantor has no title to the land at the time deed is delivered, the title automatically passes the grantee when title is so acquired, provided that the grantor asserts the quality of the title conveyed in the deed. A seller may disclaim any duty to disclose defects if the disclaimer is sufficiently clear and specific, right? The as is clause. We don't really recognize caveat emptor, but they can disclose, disclaim duties to disclose and say, we're admitting that we don't know this. And if you find it, it's not our fault. To be valid, a deed must be properly executed and delivered. A deed to a non-existent grantee, such as a corporation that has not been legally formed, is void. So if it hasn't been formed yet, you can't deed to them. An easement that is a non-possessory interest that gives one the right to use the land of another. Easements can be expressed, implied, or created through a form of adverse possession. One important thing to remember is that easements are generally perpetual, that is, they will last forever, although actions such as merger, abandonment, estoppel can terminate them. Remember, easements run with the land. If you had an easement, you sell the property, the person who buys it has that easement, unless there's something that would say no. The default tenancies is TIC. TICs have one unity, the right to possess the entire premises. They do not have right of survivorship, but JTROS is going to have the language JTRS or similar language. Order of mortgages, important. First, the cost of the sales will be paid off. Second, the mortgage that was foreclosed upon will be paid off. Third, junior mortgages will be paid off in order of priority. Finally, anything left over goes to the mortgager. Usually that doesn't happen. Usually there's not even enough to pay off the first mortgager, and we're going to have a deficiency action. Deficiency action will be either to pay the senior mortgagee what they're owed and also to pay more junior mortgagees. Okay. A non-lawyer may draft mortgage. This always comes up too, this question. A non-lawyer may draft mortgage documents if they're not doing legal work or practicing law. They're allowed to do the clerical work. The acceptance of a deed will be presumed unless explicitly rejected. Third time I've mentioned that. Need for disabled person to have assistance. The need for a disabled person to have assistant dog is greater than restriction against pets by landlord under the Fair Housing Act. So basically you can't say that no service dogs are allowed. An attornment is a substitution of a landlord in a lease. Look out for that vocab word, an attornment. A novation is a substitution of parties, like a tenant for a subtenant who becomes a full tenant. That's going to be needed for to take a novation will take someone off a mortgage completely, right? Expressly assuming will make them secondarily liable, and subject to will still be primarily liable. If you totally want to be off the mortgage, you need a novation. And then finally, a deed in lieu of foreclosure is appropriate. You can have that where it says, like, instead of foreclosing on the house, I'll give you a deed to this house. That's fair, but that will not eliminate junior mortgages. So this lecture, was thorough, so thorough that it ran into my session I'm about to do with EJ, but we're about to hop in and do MBE questions no matter what. And we went over the PowerPoint. We went over the outline, which was 32 pages and very thorough. And then we went over this cram guide. Even so, there's going to be some things on the test that, we didn't go over today. And that's fair enough. You have to do practice questions to get familiar with the material. But I'm trying to think. The quote today has been such a long lecture, but the quote today, was from Albert Einstein. What did he even say? I can't even remember what Albert said. Oh, Albert, you're killing me. He has so many good quotes on education. I had to pick. There was like 3 that I was thinking of that I have to remember. But Albert Einstein, if you can't explain it simply, you don't understand it well enough. And I think that is like the ultimate quote for a real property. I even got EJ shaking his head here because it's like, yeah, you can kind of tell me what a mortgage is, but if you really want to pass the MBE, I want you to dig deep into a mortgage and be able to tell your cousin in the 8th grade, what the elements of a mortgage are. So we went over a lot of pieces of property today. I hope you really enjoyed it. And best of luck on test day. Thank you so much.